We're going to talk about a very rare, but we've seen a rise in it a little bit of unauthorized practice of public adjusting. And we're going to talk about the appraisal process and the status of the law with appraisals. As you all probably know, the Owners versus Dakota Station case has been of interest, and it's gone up to the Supreme Court, it's gone back to the trial court, it's on its way back up again, and we will talk about that a little bit. So as we get started here, we're going to talk about some of the historic hail claims in Colorado. And you all know these claims if you've adjusted claims here in Colorado or been an expert who has consulted on damage issues with regard to hail claims in Colorado. But we've had some pretty significant claims. Starting, if we're looking back to July 30th of 1979, there was a big Fort Collins storm. 1990, Denver had a huge hailstorm. I remember that one vividly. I believe that one was accompanied by a tornado as well. Some of you might remember that hit nearby what used to be the Gates factory. And that resulted in $1.1 million in damage, adjusted to 2013. That's an older statistic, but it's a huge amount of damage. The most recent one that we all remember, and this is the one where the animal was injured at the Cheyenne Mountain Zoo, was the May of 2017 storm, where the Front Range was just pummeled. And hailstorms can be disastrous, not only to crops, but to homes. And many of you deal with crop claims, home claims, et cetera. A side note, a tangent on the crop claims. Did you all know that there are devices where they shoot something up into the clouds and they break up the hail to protect the crops? I always thought that was really interesting, but I didn't understand why they don't do that in the city as well to prevent more damage to the buildings. But I won't be able to solve that. And maybe some of you engineers and smart people out there have ideas on that you can pass along. Oh, I did want to remind everybody that the chat box is open and you're welcome to send in questions. And we might save them till the end, but if I see them, actually will be the key. We can try to answer them as we go along too. So the first thing that we want to talk about here is physical loss or damage. And when we're talking about physical loss or damage, there are a lot of different things that you can look at. And one, obviously, it's very basic. You always have to look at your insurance policy. And what does the contract provide? What are the coverages provided in that contract? Also, what are the exclusions in the contract? What are the definitions in the contract? Because that's what the courts, when they're looking at different physical loss or damage issues, will examine. So when the property structure is unaltered, and we're going to get into some specific examples of this stuff, and the insured claims the property's value, there are questions of whether the coverages have been triggered. Now, some of you of late, and I'm not going to read all these slides to you because I think you can read them and it's probably boring enough to have a PowerPoint presentation, not a live presentation. So I'm going to try not to read all of these, but some of you might have seen of late the cosmetic damage exclusions. Those have kind of changed the game a little bit. There's a lot of law, more so in Texas, on that exclusion. I haven't seen a lot of Colorado policies that have that, but I'm sure it exists as well. But basically what is being examined is whether there is physical loss or damage that constitutes something that's recoverable under the policy. So the Colorado Supreme Court, there's an old case, 1968, and the Colorado Supreme Court examined this issue in the Western Fire versus First Presbyterian Church case. And in that case, the court interpreted physical loss or damage, and it interpreted it very broadly, but this was a case of whether physical loss or damage was triggered when there was an accumulation of gasoline under the church and around the church that rendered the church uninhabitable. And in that case, the court said, well, you got to look at the specific situation. You have to look at loss of use in context of what the claim damage is and not in isolation. And so the court concluded that in this particular policy, loss of use caused by the gasoline accumulation around and under the church building equates to a direct physical loss. Now that was kind of a new thing, but it makes sense, right? Because it was a physical loss. It was something physical, even though it's a gas, that impeded the ability to use the building. Now, other courts have addressed these similar issues, and we're going to look at other jurisdictions, not because those things control what happens here in Colorado, but instead because, well, one, many of you adjust claims or serve as experts in different states. Some practice law. I don't know if we have any lawyers here today, but others practice law in different jurisdictions. And the examination of what courts have done in other states can be very helpful to see what ultimately our courts might do. Now, the Court of Appeals in Georgia in 2003 interpreted the phrase direct physical loss or damage, and they indicated that it contemplates an actual change in the insured property occasioned by an accident or fortuitous event, so the occurrence language, directly upon the property, causing it to become unsatisfactory for future use or requiring that repairs be made to make it so. So that was a pretty in-depth analysis in Georgia. The federal courts have also addressed these issues. The Port Authority of New York and New Jersey versus Affiliated FM Insurance Company, Third Circuit in 2002, said the widely accepted definition of physical damage to property means a distinct, demonstrable, and physical alteration of its structure. So it meant that there had to be something that you could actually observe that altered the structure. Moore versus American Auto Insurance, the court found that although the policy provided coverage for hail indentations on the metal roof, the policy did not require a full replacement of the roof, where the parties presented no evidence of functional or structural damage. So this is wherein this debate lies on what constitutes physical loss or damage. Sometimes the courts have analyzed the functionality aspects, also sometimes referred to as the cosmetic aspects, as opposed to just whether there are apparent alterations in the property. And when we're looking at it that way, when we're looking at the functionality that's implicated in a loss, it complicates the analysis just a little bit. The federal courts, again, this is nationwide, Trinity Industries versus Insurance Company of North America, Fifth Circuit, which is Louisiana, said physical loss or damage clause in an insurance policy did not provide coverage for defective design or faulty initial construction. Ports of Indiana versus Lexington held direct physical loss or damage clause required plaintiff to demonstrate reduction in property's usefulness or its ability to safely serve its purpose, where plaintiff alleged structural damage and cosmetic damage was not at issue. Now that case kind of gets us to almost a blurring of the functionality and the cosmetic damage. But we continue on, and I want to talk about that difference between the cosmetic or aesthetic changes. A case, Advanced Cable Company LLC versus Cincinnati Insurance, and this was a Wisconsin case. In this case, hail dented a metal roof of a commercial building. The dents were not visible from the ground. There was no evidence that the roof had been compromised or had its useful life shortened. The policy in question insured against direct physical loss. Now, the trial court in that case held that the roof had sustained physical damage and physical alteration. It went up to the Seventh Circuit, which is the appellate court, and that court affirmed, concluding that denting changes the physical characteristics of the roof and thus satisfied the physical loss or damage requirement. So in that case, even though it didn't appear that there was a loss of functionality, that court held that that was sufficient damage. Great Plains Ventures versus Liberty Mutual, Kansas case. Hailstorms caused indentations to the insured's roofs that were purely aesthetic. The indentations were not visible from the ground and did not affect the functionality or service life of the roofs. The court concluded that cosmetic hail dents physically alter an insured's property. The holding of the court was that under Kansas law, the insurance policy stating the insurer would pay for risks of physical loss or damage to covered property as a result of an occurrence provided coverage for hail indentations on metal seam roofs or buildings owned by the insured where the cosmetic hail indentions physically altered the insured's property. We're going to look at Rankin versus USAA Casualty Company, and this is a Colorado case, and it's the United States District Court for the District of Colorado, and just a little bit of a civics lesson here. We've got our state courts, we've got our federal courts. The United States District Court is a federal court. In federal court, usually the jurisdiction when we're talking about these insurance claims is based on diversity of citizenship, meaning that there are parties, the parties live in different states, and there's a certain monetary, it has to be over $75,000. Now, even though it's in the federal court, the substantive state law applies. So it's relevant to the legal issues that we see in Colorado. It's not a federal question. This case dealt with state law and state interpretation of insurance policies. So in this case, the policy in question insured against direct physical loss. Water leakage caused increased longitudinal cracks known as checking in the logs of the plaintiff's logs home. There was no dispute that this checking was normal and that the logs remained structurally sound. Plaintiffs asserted that the physical loss had nothing to do with financial detriment and they were entitled to the cost to tear down the house and rebuild it with logs containing smaller checks at a cost of $1.3 million. USAA stipulated and agreed that the checking was direct and physical, but did not agree that it was a loss. And the policy in that case, which of course always is the basis, and you have to look at the policies, defined that to a loss to mean a financial detriment. The court's holding in that case was noting the absence of damage language in the insurance agreement, agreed with USAA and held there was no coverage because the new and increased checking caused no financial detriment to the insured. Now, there's some takeaways that I want to talk about with this, but I also want to talk about some other situations that we have seen. And I'm going to be not really very specific on this, but I'm going to give you some generalities. And one of them that we've seen fairly recently was that there was a storm. It was a pretty good hailstorm, and there were two roofs inspected. One roof had some observed hail damage, and spatter observed soft metal indentations, things like that. Another roof right on the same property had a flat roof with an EPDM roofing, and the roofing's outer surface had only minor dings in it. And it's a flat roof, it's not observable from the ground. And the underlayment was not affected. There were no holes, there were no tears in the roofing material. And the issue being debated in that case is whether that damage, right? I mean, sure, it is a change in the material, but the issue is whether it is really damage. And the engineer who went out to evaluate this roof had indicated that, no, this isn't damage. This is how this roof is intended to work. And since there was no effect to the structural integrity of this roofing system, even though there was this dimpling, it didn't constitute physical loss. So it's important to work, of course, on a case-by-case basis with every claim. But when you have issues like that, it's really important to call in experts who understand the products and understand the engineering as well. So is there coverage for purely cosmetic or aesthetic changes with no discernible effect on the insured's property value? Again, it depends, but it's something that needs to be examined in every case. It can definitely be a covered loss. It can be something that needs to be remedied, and it might not be as well. And it's important to look at not only the policy, but to call in the appropriate experts when you need to. In Advanced Cable and Great Plains, the policy insures against physical loss or damage, and the court found coverage. But then we saw in Rankin, the policy insured against physical loss, and there was no coverage. The experts can really help you with these issues, but also with regard to this physical loss issue, it's been compounded, and I haven't seen any appellate decisions on this yet, but I can tell you they're going to be coming down the pike, because whenever we add exclusions or endorsements that take away coverages or add coverages, there seems to be arguments that there might be ambiguity in the policy, because if this is merely cosmetic damage, why did you not say it was excluded in the policy? So where these endorsements and exclusions are being included in other policies, there is a risk, if it is merely a cosmetic issue, that the court would find ambiguity. Just a little bit of caution there. So when do you need to call in an engineer? And that's usually whenever causation is an issue. Now, a lot of you are experts in roofing claims and are probably as qualified as many engineers to make the determinations on these causes. Sometimes, however, it helps to get a second opinion to address the issue of whether or not the integrity has been compromised, or whether or not there's an age-related component to the damage to the roof. One avenue that you all can check, but the expert can check as well, is whether the roof has been replaced. We see a lot of old roofs in Colorado, a lot of asphalt shingled roofs that are severely compromised, and really the hail hasn't caused any damage to it. The roof needed replacement before the hail, but that's a complicating factor that absolutely needs analysis every time. What's that noise I hear? What's that noise? Chris, it's time for, we have a game. It's Hail Trivia. And this is where Chris is going to pop in. And what we're going to do is Chris is going to ask a trivia question. The event will be timed. We'll give you, how long are we giving him, Chris? 30 seconds?
I thought we were just going to do first person to answer correctly in the chat. I think it's probably
okay,
the best
perfect.
way to do it. Yeah,
first
so
person to send the right answer in the chat is going to win a prize. So go ahead, Chris.
All right, so if everyone just has access to the little, on Zoom, it says chat and has a little blurb, that should be where you should type your answers. But the first question, the largest hailstone recorded in the United States had the diameter equivalent to the size of the ball used in which sport?
Eric Reese, you are the winner.
Yay!
So Chris, you want to give the answer?
There we go, volleyball. Got a little frozen.
So we had softball. Joyce, thanks for piping in. Autumn, that's a great one. Bowling ball, especially the weight would be amazing, right? And Lewis, you were just a second later than Eric in getting your correct answer of volleyball in. But thank you all very much for that. Can you imagine a volleyball-sized hailstone?
Huge.
I just can't even imagine. But I mean, obviously that has occurred, and obviously that can cause catastrophic damages. So policy exclusions, we already talked about this a little bit, but a lot of the more recent policies include the cosmetic damage exclusion. And if your policy has that, it's pretty easy to deal with this issue. If your policy doesn't have that exclusion, it becomes more complicated. So you have to look at the definitions of the different terms that are implicated, of course, to determine whether the hail is covered. Now we're briefly going to talk about ordinance and law coverage. And there's not a lot to talk about here. Different things can occur that can implicate this, but basically ordinance and law coverage is just coverage for things that are required by law to be changed when you're rebuilding. And you're seeing this, you're getting spoon-fed in here a little definition of ordinance and law coverage. But I think we all have a pretty good understanding of what that is. And we have an understanding that those coverages are defined in the policy, and they usually have their own individual liability limits and caps. And so they can be implicated, but they can be limited as well, and usually are in the policies. Now, I want to talk a little bit about some history of the law. And the Code of Hammurabi is an ancient code. It's really the first code or codification of laws that we know of. This Code of Hammurabi is in this 7-foot, 10-inch pillar of stone that's at the Louvre now. It was found in around 1900, but we have at the top, some figures, but below on that stone, there are like 280 some laws that are written in there. And the Hammurabi Code of Laws, okay, so it's 282 rules, establish standards of commercial interactions and set fines and punishments to meet the requirements of justice. And I'm saying that kind of loosely, and you'll see why. But at the top of the stele, there's a feature of Hammurabi and Shamash. And Shamash was the Babylonian sun god and god of justice. And Hammurabi claims that he was granted his rule by the gods to prevent the strong from oppressing the weak. So there was this system of codes and laws with the stated goal of preventing the strong from oppressing the weak. And to think about this, I mean, this is 4,000 years ago. I mean, it's just unbelievable, the sophistication of man over time. And that, to me, it's even more amazing that they were able to decode this stone. The ancient building codes are kind of interesting, especially when you put it up against their stated purpose. And we're just going to go over some of these because these are building codes. If a builder build a house for someone and complete it, he shall give him a fee of 2 shekels in money for each sar of surface. If the builder build a house for someone and does not construct it properly, and the house which he built fall and kill its owner, then the builder shall be put to death. So serving justice, I'm not sure, but at the time that's what they were thinking. If it kill a slave of the owner, then he shall pay slave for slave to owner of the house. Now, to me, that's kind of not preventing the strong from oppressing the weak. You know, it's not really in conjunction with the stated purpose. But these ancient building codes were set forth to ensure public safety, which really is not that different than what we are trying to do now. In the early 1900s, codes in the United States started being enacted. And in 1905, some of the first building codes were set forth by the Fire Underwriters Association. And it was more focused on property protection than safety. And those of you who look at codes often and deal with that issue understand that many of the codes that we have in effect today are working on the premise of safety as well as protecting property. During the 1930s, the New Deal, the government tried to modernize the system of housing in the United States, and building codes were popping up. And then they started developing even more in the 60s and 70s. And in the 1970s, the building codes had become very local. Most local municipalities and governments had enacted and accepted codes. So the more recent building codes, you're familiar with a lot of these, but they're still in place, but they're relatively new historically, but they're important. And as you all know, with replacement of roofs, with building of buildings, codes are definitely implicated. Local governance is the most important piece of these, but it's pretty uniform because of the federal and the trade organization codes that have been built for uniformity. So even though we do have nuanced local codes, you have to check the local codes and ordinances for every municipality, city, etc. They're pretty uniform and you can kind of know what to expect. So when we're dealing with code upgrades, we've got like, kind, and quality and code upgrade. And what are the implications of these? And as we know, you can't always do like, kind, and quality because some products such as asbestos are dangerous and they're not used anymore. Also, same with stone or gravel aggregate as ballast on a roof. Sometimes that's not acceptable. So does replacing these constitute a code upgrade? It's again going to depend on the policy language and the jurisdiction, but it can be yes and it can be no. And sometimes it is yes if the alternate material or method of repair can be accomplished, similar cost to that of using a prohibited method, and it might not be considered an upgrade, even though it really does upgrade the quality of the whatever building it is. So life in the real world, this is a situation that we've seen come up recently, and it involved codes, and it's kind of a confusing one, but I think it's a unique situation, and it's just something that I thought might be important for people to have on their radar screen. But it implicates appraisal, and we're going to talk a little bit about appraisal today as well. But in this particular matter, the public adjuster was stating that the code items after appraisal, this is when the appraisal was complete, were not appraised, and was using this county code where it's a 25% rule that the roof needs to be replaced if more than 25% of the roof is damaged and needs replacement, post appraisal to get it upgraded. So the real life tip here is if you're going to be dealing with these code upgrades, it's really important to have somebody divide out, even in the appraisal. And we've done this in the past where we have the appraisers actually identify the code upgrades because there are limits of the policy that apply to those things. So the takeaway there is address it head on. Don't think that if you just ignore it, it's going to go away, because things can arise after the appraisal occurs. So Chris, I saw that next slide. Looks like we have another Hail trivia.
Jumped the gun a bit. Let's see here. So our second question of the day, and the largest hailstone recorded in the United States weighed how many pounds? And this is in whole numbers, no decimals, just to be clear. I think it's still up for grabs.
Yep, no one's gotten it yet. We might have to go with the one who got closest. All right, Chris, do you want to grab the closest one and tell the correct answer? I can tell who the closest one is if you're not looking at the chat.
Yeah, who is it?
I think it's Stephen Thornburg.
Yep, Stephen Thornburg.
Although Jeff, I like yours too. Jeff said 720, which is really good. That's a really good guess. But what is the real answer there, Chris?
It's like 1.95 pounds. Yeah, so we just rounded up.
So 2 pounds. That's a huge stone, though. That's a lot of weight. And to me, I was kind of shocked by that, because if you think about the volleyball and you think about a gallon of milk weighing like 8 point some pounds, 8.67 pounds, I would have thought that it would have been more like 4 or 5 pounds. But 2 pounds is a lot, definitely a lot.
Yeah, there is a heavier one, just not in the United States based on my research. But if anyone wants to fact check me, my feelings won't be hurt.
So we can dispute that one apparently. So if you think you were closer to the right number, let us know. All right, So unauthorized practice of public adjusting and the laws and regulations regarding public adjusting. Now, public adjusters serve an important role in our community, and most public adjusters are above board and working to help people deal with some things that they're not comfortable dealing with the insurance claim process, and it can be a daunting thing. The definition of a public adjuster is someone who acts or aids solely in relation to first-party claims arising under insurance contracts that insure the real or personal property or allied lines of the insured on behalf of an insured in negotiating for or affecting the settlement of the claim or loss or damage covered by the insurance contract. And in that role, the public adjuster oftentimes is interfacing with an insurance adjuster, independent adjuster, or retained adjuster for an insurance company in assisting the insured in moving forward with the claim. Now, there are a lot of regulations pertaining to public adjusters, and it's a profession. You have to be a professional and you have to have a license. And I'm not going to go through all of the licensing requirements. We have that next slide that has them, but the licensing is accompanied by, not only do you have to have a license, but and you can verify the license, but you can, and you can be subject to discipline if you're not doing the right things. I mean, this is a very important job that's taken very seriously. But there are rules on what a public adjuster can and can't do. And what we have seen here is post-enactment of 10.4.1115 and 1116, there was an influx, a huge influx of public adjusters to Colorado. And as of, I think, 2012, it is, yes, the number of public adjusters went from 43 to 267 in the state of Colorado. And it's also, sorry, I have people walking through the house and I got distracted there. It's also increased with regard to certain case law that has come into play in Colorado. We saw a time where different roofers were acting in conjunction with public adjusters, and there were rules that led to stop that practice. But there's a tremendous increase in not only public adjusters, but appraisals since the enactment of this 10.4.1115 and 1116. And if you don't know what that is, that is the, sometimes it's referred to as the statutory bad faith statute. And could we go back to that other slide? I'm really sorry, Chris. The statutory bad faith statute. And basically it provides for double damages for anything that's unreasonably delayed or denied on an insurance claim. And there's incentive to some people because that claim can be, under certain circumstances, assignable. Now, the problems with the bad public adjusters, which are few, I mean, there aren't very many of them, but they do exist, is such a public concern that the Colorado government has set up stopfraudcolorado.gov with a hotline that people can use to report fly-by-night people who are pretending to act in their best interest but aren't. The issue that comes up most often with the public adjusters and this 10.4.1115, 1116 statute is when usually it's a contractor or a roofer uses that public adjusted, uses the 10.4.1115 and 6, gets an assignment from the insured for their rights against the insurance company and brings a lawsuit. Where it gets complicated and where the lines are blurred between public adjusting and what the contractor is doing is when the contractor, who is not a licensed public adjuster, starts acting as the advocate for the insured. And we're seeing a lot of that. We're really seeing an increase in that of late. Now, we can move to the next slide. There are ethical statutes that deal with ethics. Public adjusters are highly regulated and they adhere to their codes of ethics, but these other people who are doing what's tantamount to public adjusting, that is acting as an advocate on a first-party insurance claim and they're not licensed public adjusters might be crossing the line from time to time. There are also statutes that govern the conflict of interest that might occur with regard to the public adjuster and the work that they're doing. And although licensed public adjusters don't step in this, the people who are acting as the public adjusters, say the contractors who are also advocating for the insured, sometimes can be violating these conflicts of interest and other regulations. If we can turn to the next slide, there are general ethical requirements, and the one that we've seen be violated, usually by a contractor, is this number 5, the V down there. A public adjuster shall not enter into a contract or accept a power of attorney that vests the public adjuster the effective authority to choose the persons who perform the repair work. So what we've seen is that certain contractors or roofers are acting as the first party advocates, that is the public adjuster without a license, and they're referring the work to themselves, which can be a problem. Now, what you can do about that, you can report them as practicing without a license, but beyond that, I really don't know much you can do unless the case is in litigation. So the blurring of the lines, and we're going to skip ahead a couple here because we're getting a little bit tight on time. Blurring of the lines between the roofer contractor acting as the advocate through assignment. We've also seen, let's see here, the rooftop restoration case was another example of where the lines were blurred. We all know that case, at least in the legal field, because it held that 10.4, 1115, and 1116 were not punitive in nature and weren't subject to the 1-year statute of limitation. But the case is deeper than that. And the case is really involving the blurred lines between the contractor and the public adjusting aspect of the claim. Now, the developing issues that we're seeing are mainly, Chris, do you mind turning the page here? Thank you so much. Are primarily anecdotal. There's not a lot of case law on this other than really rooftop restoration and then owners versus Dakota Station. But in rooftop, we did have a couple of takeaways. The public adjuster shall not have direct or indirect financial interest in any aspect of the claim other than the salary, fee, commission, or other consideration. And a public adjuster shall not refer or direct the insured to get the needed repairs or services in conjunction with the loss if that public adjuster has a financial interest. And the public adjuster shall not participate directly or indirectly in the reconstruction, repair, restoration, or damage of the property. And they won't accept power of attorney that vests the public adjuster the effective authority to choose the persons who perform the work or repair. And so you can see with those developments, with those guidelines, with those rules, the contractor who's acting as the advocate for the insured is definitely blurring the lines between acting as a licensed public adjuster and also blurring the lines of maybe stepping into some bad territory of acting as a public adjuster, referring work to someone who the contractor has an interest in. And now it's time for another break and another trivia question.
All right, our third Hail trivia question of the day is going to be for the geography heads out there. So this city in which country, looking for the country, experiences more hailstorms than any other city in the world?
Jeff, Richard, you're amazing.
May have slipped up and gave the answer, but I don't know if you saw it. But yeah, I'm probably mispronouncing that. Has an average of 50 days of hail per year.
Oh, you guys saw the answer? Oh, Chris, we have to do another trivia question then.
Okay, give me a little bit.
We'll come up with another one, but you can still win, Jeff. It's okay. We'll let you win. Okay. The appraisal process. So appraisal, like the increase in public adjusters, I've been practicing law in Colorado for 34 years. I first started seeing appraisals being requested on property claims probably in around 2008 or 2009. Could have been a little bit earlier than that, but it was just a huge change in the way people were looking at the policies and invoking that clause. Now, we all know that that clause has been invoked for a long time in different states, Florida, Texas, primarily. And it can be a useful tool, the appraisal process. If there's a dispute with regard to value, the parties can't agree, they can agree to the appraisal process. It's the seminal appraisal case in Colorado, Owners versus Dakota Station. This was a case in which a homeowners association, a rather large one, had set their reserves for new roofs. They'd had 3 bids for new roofs. There were all kinds of factual issues. Maybe these roofs, probably these roofs needed to be replaced before the appraisal clause was invoked. Pre-litigation, there was a dispute with regard to the value of the claim. Appraisal clause was invoked and it went to appraisal. The umpire, all 3 parties were involved. So there were 2 appraisers, one for Dakota Station, one for Owners Insurance Company. And the umpire was a former judge. In that case, the Owners Insurance Company's appraiser would not sign off on the appraisal award. The appraisal award was about $3 million. And I won't get into the nuances and the facts of this case because it is still being litigated not only in federal court, but it's been up and down in the state court as well. But in this case, the most important thing is after the litigation was filed, owners received in discovery some things in the homeowners association minutes that indicated that they might have had some issues. There was evidence of meetings with the appraiser, and there was evidence of the appraiser giving opinions of the value of the loss before the appraisal ever took place. So in the state court action, owners filed a petition to vacate the appraisal award. There was a full-on trial, 3-day trial, evidentiary trial with witnesses, exhibits, just like you would with a jury, but it was to the court. Following that trial, the trial court held, well, no, the appraisal provision does not require that the appraiser be disinterested. The trial court said that the appraiser was really more aligned with an expert witness, so they could advocate the position of whoever hired them. So that went up to the Court of Appeals. And at the Court of Appeals level, there was a split in the decision. And the one judge who dissented, Judge Terry, held that the Court of Appeals held that the term impartial was ambiguous and found that because the policy provided that an umpire was to be appointed, that in and of itself indicated that the other 2 might not have to be impartial because the umpire was ultimately to decide. Judge Terry disagreed with that. She dissented, and she said you have to look at the plain language of the term impartiality, and looked back at what we had argued at the trial court level to be the seminal case, the Providence Washington Insurance Company versus Gullinson case, and said that even though they aren't referees, their duty of impartiality is the same, and said that she disagreed with the majority. Well, it went to the Supreme Court. It was appealed to the Supreme Court following the Court of Appeal. Oh, this is just an interesting, we'll go back to that black and white photo. This is just an interesting photo that we pulled to show that even in the 1920s, they were litigating hail claims. This is a picture of the time period of that case, Providence versus Gullinson. the case of Owners versus Dakota Station went to the Supreme Court, the Colorado Supreme Court, and the Supreme Court reversed the Court of Appeals and rejected the idea that the appraiser does not have to be impartial, and interpreted the policy to be that the appraisers have to be impartial, and remanded to the trial court. The case went back to the trial court, and there was another several-day trial to the court. And after that trial, the trial court held that the appraiser involved that was hired by Dakota Station 2 was partial, and that the appraisal award was vacated. From that, and mind you that the appraisal award had been paid, and I think it was around, well, north of 3 million, it might have even been higher, had already been paid. So it kind of, to quote the trial court judge, she said, it's really hard to put the toothpaste back in the tube. And anyway, the toothpaste is not back in the tube, and the case has been appealed now to the Court of Appeals, and we'll just have to bide our time and see what happens. Right now, the controlling case is the Colorado Supreme Court case that holds that appraisers are not advocates, and the standard of impartiality, the appraisers must be unbiased, disinterested, and unswayed by either party or personal interest. And appraisers should disclose relevant information, avoid conflicts of interest, and should not have ex parte communications with the parties. So with that, if Chris has another trivia question teed up, did you find one?
Yeah, I got a makeup trivia question.
Okay.
But still going with geography. So going back to the heaviest hailstone recorded in the United States that weighed 1.9 pounds, which state did it fall in? And then I don't want to try and look at the chat. Actually, doesn't matter. Let's see here. So it looks like Lewis Fanasha got it correct. South Dakota is where the heaviest hailstone recorded in the U.S.
Yay! So we do have some time for Q&A if you all want to have us address any questions. But while you're thinking about if you have questions, for those of you who are announced as winners, just put in the chat your email address and we will email you your prize. Or you can give it to Kelly, your email address to Kelly, and she'll give it to us. Either way.
Yep, I have everyone's email here, so that way it makes it easy.
Okay. So that's great.
All right. Were there any other questions? I see something happening in the chat.
How many hail claims or losses go to court or need an attorney? And needing an attorney and going to the litigation process are two different things. And I don't really have statistics on that, but I can tell you that we litigate a lot of property damage hail claims. Not as many as the bodily injury hail claims. And usually, well, even if it's after appraisal, we litigate these in state and federal court. So most hail claims just get resolved, right? Most claims just get resolved. The parties communicate. I think communication is key, and they agree upon what the loss is in the amount payable, and they're fairly paid. There are times when one side or the other doesn't think that the process is going in accordance with the way they think it should go. It might be a lack of communication. It might be other things going on, but we do litigate a lot of hail claims. The litigation of the hail claims involves all of the things we've talked about. So all of the coverages and a lot of engineering. We usually rely on engineers when we're litigating these cases to determine the different implications. Like the one that I had talked about with regard to the cosmetic damage with the EPDM roofing, that of course we have an engineer involved in. We've got claims where we have asphalt shingles and there's just a lot of granular loss, and there's no evidence of any, there could be some damage to the soft metals, et cetera. Oh yeah, somebody wants to comment on granular kiss versus hail. Absolutely, Rich, you can definitely comment on that. If I don't know how to turn your mute button off, but
I think he's asking for you to comment.
oh, can I comment?
Granular kiss versus hail loss.
No, I would rely on someone else to do that for me. I've never inspected a roof. I've heard a lot about it. I've heard a lot from different experts on what to look for in the darkening and the light color and the different things, but I'm not a roof expert at all. I litigate roofs a lot, but yeah. So if you have any other questions, if you think of something later, feel free to email either me or Chris. Our email addresses are Karen@Wheeler5280.com. And Chris's is Chris@Wheeler5280.com. 5280, just, most of you know that, but that's just the Mile High City. So I was born and raised here and love it here. So we adopted that in our name. So thank you all for your attention today and your time. We very much appreciate the opportunity to speak with all of you. And we're very much looking forward to June 18th for your golf tournament. We will be on a hole and we will also be playing. So look forward to seeing you then.
That's excellent. Thank you so much, Karen. And thank you, Chris, as well, for all your help today.